Thanks for staying with us. We are now going to our second half topic, and the House of Representatives has proposed decentralizing Nigeria's Supreme Court by establishing 5 regional divisions in Umuahia, while Abuja would still serve as the North Central region. Legal experts, including NBA's Bridget Edokwe, argue it would allow quicker, would also ease the Supreme Court. Our guest this morning is Barrister.
Good morning. Thank you for having me.
What do you think about this?
What I see that we are trying to do is treating the symptoms rather than the disease. What this centralization seeks to achieve is to bring the Supreme Court to various divisions in an attempt to bring it closer to peace. But the problem of the Supreme Court, essentially, the real problem of the Supreme Court is not necessarily the fact that it's sitting alone in Abuja. The major problem of the Supreme Court is the fact that the court is overwhelmed by irrelevant cases. The court is overwhelmed. The court is overwhelmed by the fact that there's some sort of system that should be heard by the leave, what they call the leave process. But, it's not, I don't think it has been effective. So the Supreme Court today, if you see all the judgments come from the discussion about procedure, if you look at the US, the design of the Supreme Court system, you find out that only few cases of constitutional importance goes to the Supreme Court. And they have just 9 justices and a few supports, and they're able to handle all these cases because few cases go there. But our Nigerian Supreme Court here, all manner of people over loans, all manner of cases. That shouldn't be the case. The idea of the Supreme Court is that the court hears matters that borders on where the Supreme Court should be focused, so that you limit the kind of cases that should go to the Supreme Court. Once you do that, you might not even need all these divisions. In fact, you can then now say that each of the states, or you can have regional Supreme Courts that will hear appeals from the states. And only very limited specific cases that borders on constitution will then go to the Supreme Court. That would be a much more better approach than this approach of trying to treat the disease, the symptoms, which is the symptoms that you have. The court has so many cases. It's taking almost forever for judgments to be delivered. And in fact, I have cases at the Supreme Court that I don't even know whether we're going to get dates, and we're already 5 years down the line or more. So so we are trying to look at that symptom, but that's really not the proposal. I haven't seen the details of the bill. I should get involved in this process so that we can have something that.
Before we get to the Supreme Court, what about the lower courts and all that? Do we have the correct infrastructure? Do we have enough infrastructure? Do we have everything that it takes to make those ones work and function as they should optimally? Or are we just looking at the Supreme Court and then that is it? What other problems are we facing in the judicial system regarding the lower courts than the Supreme Court?
I have always said that we are not serious with justice delivery in Nigeria. I think we just play lip service. We just talk about it. We don't, look at the fundamentals of what it takes for us to have an effective justice delivery system. You talk about the infrastructure. It is completely zero. Across the country, I've had the opportunity of appearing in almost all the major capitals in the country. You see judges taking funding. Judges don't have enough support. The what do you call the registry of the courts are not properly do not have properly trained staff and motivated staff, in terms of that you have so many cases, language. A case that Chief Rotimi Williams of blessed memory, the Timidi law, started in 1990. So the reason why you have that, I was supposed to have a matter at the National Industrial Court where a judgment, there's supposed to be what we call adoption of final written addresses. But it couldn't be done, but because the judge, I got notice that they can't go ahead because the judge already has so many judgments to write. And so you cannot be adding other ones. We don't have enough judges. We don't have enough courtrooms. We don't have, we don't have proper training for judicial officers. We don't have enough support for the judges, and the environment is not conducive for them to do their work. the infrastructure, the technology is not there, because today there are technology that summarize for justice delivery is also not in proper shape. And then there are other problems that we have. We have this craze to becoming a senior advocate of Nigeria, and that has resulted in all sorts of frivolous appeals being filed by lawyers in an attempt to have the number of cases they need to get from the Court of Appeal, from the Supreme Court, from the High Court. All sort of appeals are being filed. In some cases, even the clients may not even be aware. Also review that all of that process, so that we can focus on substance rather than all these shadows we are chasing, all these perennial objections, all these and these are some of the reasons why we are where we are. So we need to look at a holistic approach to the reform of the judiciary, rather than which is reviewing the law to limit the number of cases that go to the Supreme Court. And then you can now focus on proper infrastructure at the state Court of Appeal levels to ensure that judges are able to do justice. Today, what we have is a semblance of it. What we have is just an attempt to give a false impression that we're interested in justice. We're not.
Talk about the fact that we're not. You say it is the government. They will tell you that's the reason they are building judges' quarters for the judges. That they will tell you that's why they have increased their remuneration and all that. It seems as if the executive is doing for the judges or for the judiciary what.
Quite frankly, it should be everyone. Not forget, unfortunately, judges cannot actually speak for themselves. The kind of oath they have taken, the kind of legal system that we have designed, and judges are not to be heard in public. You can, for example, coming on the street or coming to the television to talk about the problems they have, in order to deliver justice. So the major stakeholders, all the stakeholders must be involved in this process. And the starting point is the Attorney Generals of the states of the Federation, who, being lawyers themselves, are supposed to liaise with the executive, judiciary, and, come up with solutions that would ensure that we have an effective justice delivery system. So you also have Nigeria. It seems to have lost the way in terms of galvanize the system towards an effective judiciary. So you have all of that. Then the government, in terms of solving the magnitude of the challenges that we have with justice delivery. I've just talked about the skilled sets of the and the way and manner we award costs against litigants who file frivolous cases. All of these are some rooted in tradition of the courts, of the judicial system, and some rooted in our law. So we need to amend the law, for example, to ensure that you don't just file frivolous cases. And then I've talked about also be reviewed if we are serious about an effective justice delivery system. This system that focuses on number of cases gotten from the Court of Appeal, from the Supreme Court, which is crippling the system. We need to review all of that so that we can all, work towards ensuring that the system works. So it's basically all the stakeholders. Journalists like yourself, what you are doing now with this report, it's all part of the process of ensuring that we have an effective justice delivery system. Everybody must be involved. Government cannot just focus on what do you call it, on judges' quarters and salaries alone. We need to, for example, look at, is anybody doing the statistics of the number of cases that are filed every year, the number of cases that are resolved by judges every year, the number of substantive disputes that are resolved, and is anybody doing the mathematics on what can be done to make judges more effective? There's a recent move in Lagos to try to ensure that cases judgments are delivered within certain timelines and all of that. But for that to be effective, you need a lot more judges, a lot more. It is quick. But the rest of us, the people, we don't have access. All of these political cases are time bound. There's a time within which the judgment will deliver. So, the people who are doing those cases now are the ones that can easily become senior. There should be timelines, for cases to be. It's one of the biggest responsibilities of government. Ensure that there's rule of law. Ensure that there's justice in the land.
Does it need any constitutional tweaking? Does it need any constitutional adjustments for the judiciary to get the kind of...
It requires a serious constitutional amendment. For example, if you want to deal with the congestion in the Supreme Court, that reducing the number of cases that goes to the Supreme Court, you have to amend the Constitution to achieve that. Even for the states, the Court of Appeal, in order to reform all of this process, you need to amend the Constitution. You need to amend the Legal Practitioners Act on the process of elevation to the rank of senior advocates. And then you will need to also look at constitutional. I know that in recent times there was constitutional amendment to ensure autonomy for the judiciary and all that. We need to take it more seriously, so that you now have a department in the judiciary that takes stocks of the infrastructure on a yearly basis, that takes stock of the cases that the way amount cases are moving on a quarterly basis. Then ensure that judges are doing their job. Ensure that you have a proper, well-trained support system for the judges to make their work easy. Ensure that the technology is, and so these are some of the things that we need to do in order to ensure that we have an effective system. We must amend the Constitution, quite frankly. And in amending the Constitution, we must look deeper into the disease that is afflicting the system. We shouldn't be of a diseased system, and the disease is something we need to find and look for a constitutional remedy for it. And I've just mentioned the constitutional remedy for the Supreme Court, the congestion at the Supreme Court. You need to do that. Even for states or regions, you have the Nigerian Supreme Court can only be approached on very serious constitutional matters and on very serious on issues that bother on fundamental rights of citizens. And that's what you have. That's why the U.S. Supreme Court, with just 9 justices, can handle their Supreme Court cases at the Supreme Court without yes, they have some congestion, but you can't compare it to what we have in Nigeria. And so yes, there's constitutional amendment, which is why this attempt being made by the National Assembly is supposed to be an opportunity, and that's why stakeholders must get involved in this process so that we can direct the National Assembly on the right path of solving the problems and challenges of the Nigerian judiciary.
Okay, well, all hands must be on deck, as you have said. We do hope that something good will come out of this, and the judiciary, the much needed reforms will come. Some of us thought that maybe this case of Farotimi and Afe Babalola will unearth some things. It will not see the light of day anymore, but that is a case for another day. For today, we'd just like to thank you, Barrister Asia, for coming on the program and sharing your thoughts.
Thank you for having me on the program.
We'll be talking with Barrister Elvis Asia, proper reforms that will give us a better judiciary than what we have today. And that is how we wrap it up on the show this morning. We thank you for Agaji. Bye for now.